So as you can see, we have a seminar on the empty chair defense today, and so we brought a chair in front of us. If you don't know about that, that's something you'll learn about as soon as you start litigating. So my name is Michael Vanderbilt. I am a professor of law here, and really excited to welcome our panelists and the audience. And the students have done a terrific job pulling this all together. This is the first of two events that we're going to do for the Environmental Law and Policy Annual Review this spring. One here, and then one on Friday in Washington, D.C. at the headquarters of the Environmental Law Institute. So thanks to ELI and to Linda Bregan for co-sponsoring this project, helping provide some of the intellectual force behind it, and the connections that ELI has around the U.S. and around the world. Ultimately, this empty chair is going to be occupied by the Vice President for Research at the Environmental Law Institute as well. Let me say a word or two very briefly about what we're trying to achieve with this project. The Environmental Law and Policy Annual Review is first and foremost an effort to try to give students an opportunity to understand and participate in the process of writing about and developing environmental law and policy in the United States. And so we are trying to give students an unusual experience. I think it's truly unique in the original sense of the word, in that the students here get to pick the best articles from a policy perspective from the 500 or so published by Tom and Linda and me and JB, who's here in the room, in the prior year. Secondly, we are hoping to use the Environmental Law and Policy and Review process to move the very best policy ideas generated in the academic literature into the policy debate. We have a great deal of very smart people who are often writing to each other and occasionally having this sort of existential sense that they don't really know if they're having any difference, and the unfortunate answer is they probably are not most of the time. So we're trying to move ideas into that policy world as much as we can by producing very short, very to the point, low footnoted pieces with commentary from across the political spectrum. And that's one of our core functions. We're also trying to provide incentives for legal scholars to actually write about the policy implications of what they do, to give them incentives for not just cutting the policy implications off in the last third of an article, but actually take the theoretical work that they do and bring it to bear on specific policy problems. We hope, and this is our fourth goal, that that will also improve the theoretical quality of the legal scholarship out there, because it's very easy in our field. If you need a can opener to open a can, you just imagine a can opener, hypothesize a can opener, and off you go. But anyone who's been in the real world knows that that's not the way it really works. So we think that when scholars actually write about policy ideas, the quality of their theoretical work will be much better. They'll be much more rigorous, much less likely to assume away the real barriers that policymakers face. So that's our goal here, and I think the piece that we're going to talk about today and the event today is just a great example of what we're trying to achieve. So with all that, I'm excited to turn the program over now to Jade Malgalles, and we'll go from there. Okay?
Thank you guys. Good afternoon, everyone, and welcome to this year's ELPAR Nashville conference. My name is Jade Malgalles, and I am this year's executive editor for ELPAR. It brings my team and I great pleasure to see you all here and to see this conference come to fruition today. We started this process a little over a year ago with 1,031 articles. As a journal, we reviewed each article, discussed and debated the articles in class, and by the end of fall 2018, we narrowed the pool down to 20 articles for our advisory committee to review. With the committee's input, we selected 8 articles to publish in this year's annual review. I applaud the authors for their work and contribution, because it's really not an easy feat to publish an ELPAR. To qualify for selection, an article must meet 2 prongs. First, the article must address an environmental quality issue of major importance. And second, it must offer a law or policy-related proposal or approach to rectify the stated problem. After qualification, we consider additional factors for publication. We debate whether the article is persuasive, impactful, feasible, and creative. It is this rigorous process that has led us to select only 8 articles for this year, one of which you're going to hear more about today. After selection, ELPAR students condensed the chosen articles to 10 pages, emphasizing the proposal section for policymakers to evaluate. The Environmental Law Institute, ELI, is a nonprofit organization in DC that focuses on creating environmental policy solutions that help us recruit experts to comment on the articles to broaden the scope of the discussion. ELPAR members then edit these comments and publish them alongside our condensed articles by the end of the summer. During this process, we invite the selected authors to 2 symposiums, one held in Nashville and the other one in Washington, D.C., where we host panel discussions with expert policymakers and practitioners who comment on the article's ideas while allowing the authors to respond and give the public an opportunity to participate. So to start this year's Nashville conference, I'd like to turn over to Professor Linda Brigham, our senior attorney at ELI, and our ELPAR professor. She will introduce our first set of speakers. Thank you.
Hi, everyone. Thank you, Jade. And thanks really to the entire ELPAR group. We've had a terrific group of students this year, and it's just really been a lot of fun. And thank you to all of you for joining us. So the way this is going to work today is that we are going to hear from the professor whose article is selected, and he's going to talk for about 15 minutes or so. And then each of our wonderful commenters, including Jay Pendergrass, who is going to be joining us eventually, he just got stuck in a meeting, and each of them will speak for 10 minutes. And then we're going to give the professor a chance to respond, which is always, I think, one of the more interesting parts. And then we'll go to questions and discussion among the panelists. Now, I know many of you all have class. We're just happy that you came. When you need to leave, leave. We will try to wrap up the presentations before you need to leave for class. So you all, I hope you won't think I'm rude if I'm making, motions at you to, wrap it up. But then we'll continue, for another half hour just with discussion and questions and answers. So thank you so much for being here. I'm going to hand it over to Emma Staff, who this would not be possible without her incredibly hard work and great job. So thank you, Emma, and here you go.
Hi, thank you all so much for being here. I am the Symposium editor, and it is my pleasure to introduce our distinguished panel. Professor Thomas Littinger is the Orlando John and Marion H. Hollis Professor at the University of Oregon Law School and the author of Green Ethics for Judges, which was published in the George Washington University Law Review. Prior to joining the University of Oregon in 2003, Professor Leininger had worked as a federal prosecutor of the environmental crime, as counsel to the subcommittee to the U.S. Senate, and as a litigation plaintiff's attorney who sued polluters in San Francisco. This experience has led to his current research interest in the intersection of environmental law, ethics, and criminal procedure. Professor Leininger has also served on the State Board of Directors for the Oregon Natural Resources Council. He is the ethics advisor for the Sustainable Future section of the Oregon Bar, and he is a member of the ethics committee for the American Bar Association's section on environment, energy, and resources. Amanda Garcia is a managing attorney at the Southern Environmental Law Center's Nashville office, where she works to reduce reliance on fossil fuels in the electric utility sector in Tennessee using a full range of regulatory, legal, and communications tools. Prior to joining SELC, she clerked for the Honorable Alice Marie H. Stotler in the United States District Court for the Central District of California, and then practiced public interest international law in San Francisco. She has also taught federal courts and negotiation at Belmont University College of Law as a visiting professor. Lucian Pera is a partner at Adams & Reese LLP in Memphis, Tennessee. In addition to his commercial litigation and media law practice, Mr. Pera has enjoyed a multitude of experience and leadership in bar associations. He was involved in the most recent complete revision of the ABA Model Rules of Professional Conduct and is the immediate past chair of the Coordinating Council of the ABA Center for Professional Responsibility. Mr. Pera has also served in other leadership positions of the ABA and has served as the president of the Association of Professional Responsibility Lawyers. He is also the immediate past president of the Tennessee Bar Association. Due to this experience, Mr. Pera writes frequently on legal ethics and presents on this material to national audiences. John Pendergrass, our resident ghost, who is joining us via webcast from the Environmental Law Institute headquarters in Washington, D.C., is the vice president of programs and publications of ELI. Mr. Pendergrass leads the Research and Policy Division, which conducts legal and policy research and analyses of pressing environmental and natural resource issues. In addition to these responsibilities, he leads ELI's Judicial Education program to educate judges from around the world about environmental law. Since the program's initiation in 1991, ELI has developed, presented, and participated in educational workshops on critical topics in environmental law for more than 2,000 judges from 25 countries. Thank you all again for coming, and let me hand this over to Professor Leininger, who will provide an overview of this article.
I'm hoping this is going to work. Okay, well, we're just going to have to wait. And oh, there he is. Okay. Hi, Jay. Welcome. And by the way, this is what ELPAR looks like, the publication. I'm just going to leave it up here in case anyone wants to look at it afterwards.
Well, thank you very much for coming today. I want to begin by saluting my hosts, Linda, Mike, and all the students involved with ELPAR. Thank you so much for selecting my article. Thanks for your hospitality now that I'm here. Linda mentioned that she appreciated my sacrifice in coming from Oregon to Nashville, and I said, are you kidding? When she typed me the email that said, would you please come to Nashville and present your work, I was trying to respond like the instant I read the first sentence. So I was very thrilled to come. In particular, I was telling my boys, who are maybe not so familiar with the academic scene, I said, hey, I have a chance to present one of my recent articles to one of the top law schools in the country. They said, yeah, whatever, Dad. They're not often impressed by what I do. And then I said, but also in the room will be an expert from the ABA, a leading environmental activist, a leader from one of the top think tanks in the US. And my son said, yeah, right, Dad, you're slightly interested. I said, all right, well, now I'll reveal the showstopper. 70 free Chipotle burritos will be served because of my scholarship, and the boys' jaws just dropped. They said, you are a rock star, Dad. I think that's how we should now gauge scholarly impact. Not citations like J.B. Rule tends to rack up hundreds of every year, but how many burritos were served because of your articles? That's the real gauge of scholarly impact. Wanted to thank the fellow speakers who are sharing the floor with me today. And I think what I'll present today is in some respects controversial. Perhaps it goes too far. Perhaps it doesn't go far enough. I've heard criticism from both sides. But I just want to acknowledge the expertise. I know Amanda Garcia is doing hugely important work, and I think her career should be a model for anyone considering how to have a real-world impact in environmental law, with coal ash advocacy leading a regional effort to improve the environmental safety throughout the South. And I've gotten to know Lucian, Pera, and he's a fascinating, charismatic man. I know he's probably got a few misgivings about my scholarship, and I'm trying to soften it by flattering him in advance. But what I love about his writing online is he uses, without apology, the term ethics nerd, and he appropriates it. He owns it. I'm an ethics nerd, too. They bring me in for scholarship discussions. They say, oh, bring in the ethics nerd. I'm like, why is it never the ethics champion, the ethics expert? Nah, it's the ethics nerd. But they hate us because they ain't us. Am I right? Am I right? And then I've had occasion to work with ELI, and in fact, some of what I'll present today was born in a 2016 workshop at ELI about the ethics of scientific uncertainty. They've really been on the cutting edge. And then Jay Pendergrass has been training judges for decades throughout the world, and he's going to have some really important insights to share today. So I consider it a great honor and a great opportunity to share my ideas in the presence of these speakers. Also, I recognize there's a lot of expertise in the room. Whether you're a student, a practitioner, an author in this area, I will look forward to hearing your comments if time permits today, or if you'd like to contact me by email. It's my last name, Leininger, Lininger, at uoregon.edu. Mike began with a metaphor about a law professor hypothesizing a can opener. I think this is the great role that ELPAR's project fills. ELPAR is a bridge between the sometimes esoteric world of academia and the real world that many of you inhabit, where the rubber kind of meets the road. And I will confess that my hypothesis of how to open a can may be sort of analogous to dropping the can from a great height, bludgeoning it with brutal force. I'm not sure I've got the right ideas. I do know, however, in my heart, that there is a place for reform of the ethical rules for judges that would, if not solely, incidentally promote cognizance of environmental harm and also encourage response that would minimize such harm. Let me just explain the genesis of this project. I'm going to tell you a bit about the background, what led me to write it, and then I want to share with you some of the highlights, but I'll certainly welcome comments about anything that I've written in this piece. Here's how I became interested. In the year 2016, I wrote a piece called Green Ethics for Lawyers. My scholarship seems like one of those long series of Hollywood sequels where you kind of wonder, did we really need the second one? But I began with a critique of what historically has been the orientation of the ABA's regulation of lawyers. I say this respectfully. I have the highest respect for the wise minds that figure out the rules that states mostly adopt to regulate the legal profession. But I will say that as one who's deeply concerned about environmental health, I realize it's not ideal from a policy standpoint that lawyers' first obligation of loyalty is a very partisan, client-centered orientation. And I think, I teach legal ethics. I've taught that longer than I've taught environmental law. And that is the core tenet. It is the biggest part of the lawyer's ethical rules. Those rules that command sort of undivided loyalty to clients, confidentiality to clients, and subordinate third-party interests. Now, I want to commend my new friend, Lucian, who was part of the Ethics 2000 task force that was part of the trend to begin recognition of third-party interests that might merit disclosure. And so far, it's mostly permissive disclosure, but increasingly, over the last few decades, the bar has begun to recognize there could be external interest, that is extrinsic to the lawyer-client relationship, that would justify permissive disclosure of client information. One example is imminent physical harm to human beings. And so, for example, you know that 1.6b1 allows lawyers to disclose imminent harm where disclosure would help, right? So too, if child abuse is at issue, this varies state by state, but it could very well be a basis for permissive disclosure. In the year 2002, we saw corporate meltdowns throughout the United States, and some lawyers were sleeping at the switch. And Sarbanes-Oxley was federal legislation that began the scary prospect of congressional regulation of lawyers' ethics. And then the bar, in an update in 2003, began to create some new disclosure grounds, which, technically, those under 1.13 are not external because it's an organizational client, but 1.6b2, b3, recognized that harm could befall human third parties such that a lawyer might justifiably disclose client information to avert that harm. And here was my basic idea that pretty much animates my scholarship on this subject. Why is environmental harm not also considered an equally compelling basis for departing from the normal client-centered orientation of lawyers? And so I've written about the application of these theories to lawyers, and now my topic today is about the application of these theories to judges. If one can posit that legal ethics should be reformed with respect to lawyers, it stands to reason that judicial ethics should also be reformed. Now, I will grant, judges are not partisan, in the sense that they are not client-centered, right? They may very well come from a partisan background, but in the sense that they do not have loyalty to one side, perhaps that reduces the urgency to change judicial ethics if judges basically have a neutral orientation. And yet, I would argue, it perhaps lowers the impediment to such an approach. And I certainly think that judges are increasingly facing sets of facts that put at issue some of the considerations we'll discuss today. I also think, as you can see, and I come from a state that's on fire, frankly. My state's on fire. The West is ravaged by environmental harm. I think we are in an era which may be analogous to wartime, in that it's time to think outside the normal framework. And I think Mike and his scholarship has raised such important ideas about reaching beyond normal government frameworks to consider, if not imposing duties, to consider the possibility that private governance and individuals either motivated by conscience or perhaps well-crafted ethics rules might take up the cause of environmental protection, and I think there's a place for judges in the mix as well. Let me lay out some ideas. What I'd like to do is first kind of quickly go through some straightforward ones, and then tee up a controversial one that I'm going to guess Lucian disagrees with. I will begin, and I don't mean to use the singular, because I bet Lucian's got a few that may seem more like bludgeoning the can than opening the can. I will start with a few that I regard as straightforward, and one piece of my article that was omitted in the ELPAR version is the consideration of whether we should have customized ethics rules that apply uniquely in environmental cases before judges, or, which is normally the ABA's approach, should we have across-the-board ethics rules that aren't limited to a particular context, save for criminal cases, it's hard to imagine that the ABA often has particular compartmentalized rules for particular contexts. My preference would be across-the-board reforms that could apply equally in a large-scale tort case or an environmental case. Here's some ideas you'll see in the article. For example, judges presently have an obligation not to make decisions that are inconsonant with the law. They must rule in accordance with the law. Lawyers, in Rule 3.3, have an obligation never to misstate the law or to misstate facts, even with respect to immaterial prospective statements under 3.3. But judges have no obligation to find facts accurately, other than, of course, the risk of appellate reversal. It is not an ethical duty, at least reflected in the ABA Model Code of Judicial Conduct, for judges to make accurate factual findings. I offer one anecdote, which I'm sure is the tip of the iceberg. In the state of Washington, we had a judge who simply declared global warming is a speculative theory, that it's not so clear, even though 97% of scientists in this NASA study have found that human-caused activities are linked to global warming. I believe to deny climate change is wrong at an ethical level. But I would not limit such a rule to the context of environmental harm. I think judges have an ethical duty to find facts accurately, and in a world where scientific findings, I suppose with respect to coal ash, it's very important that judges understand and correctly assess scientific facts. This is one idea I have to change the judge rules. Greater transparency is another priority. One rule that may be salient, because we've all recently watched Supreme Court confirmation hearings, I would like to see across-the-board changes in ethics rules that allow forthright and candid discussion by judicial candidates of their views on all issues, whether environmental or others. Now, I know technically the Pledges and Promises Clause is a rule that only forecloses judges from discussing how they would vote on matters pending or impending in their courts. I know practically, in confirmation hearings, judges duck discussion of controversial issues on the ground that, I would love nothing more to discuss in great detail my views on abortion, on issues that might very well sink my confirmation, but I can't because of those ethics rules. So a lot of what I propose in this article is tinkering that's not so controversial. Now I got a controversial one. I believe that the precautionary principle should be an ethical obligation of judges. This is somewhat radical, as I learned when I presented in Texas. So there's nothing you can do to me that Texans have not yet done. I believe that the judicial enterprise ought to be inherently cautious. In fact, if you consider the colloquial meaning of the term judicious, it is, cautious, trepidatious, right? Judges, in so many respects, are counseled by the Code of Judicial Ethics to be abundantly cautious with respect to possible conflicts of interest that might necessitate disqualification. To be abundantly cautious when contemplating any sort of action that might appear to diminish the impartiality, even raise the appearance of somehow demeaning the high station of the judiciary. Here's what I think. Now judges ought to be instructed that when arguments for and against, let's imagine the example of a development proposal, are at or near equipoise, meaning balance, and furthermore, there exists credible evidence of a catastrophic risk, which I tried my best to define, and I'll bet I didn't define as well as a critic might point out, that in that circumstance, erring on the side of caution is not just prudent policy, but is ethically required. And I surveyed other fields in which the precautionary principle is indeed a tenet of ethics. And it seems odd to me that judging does not include a presumption in favor of the status quo. I think what you will see, depending on the context, is judges deferring to recognition of and respect for private property rights, which makes sense given our Constitution, but is not always necessary. I think there's also, and this is Chevron and its progeny, there's a deference to administrative approvals of pending development projects. But what I do not see as explicitly as I believe caution would dictate is the notion that when catastrophic risk is at issue, don't build it. And now I can foresee, and I've got a minute left if I'm keeping track of my time, I can foresee a number of objections, and I want to just sort of recognize them in advance and begin addressing them. One is, how on earth can the ethics rules tell judges how to judge, right? How on earth can the ethics rules interfere with judges' discretion to pick whatever outcome seems appropriate? And I'd argue, and I salute some of these recent changes, we already have some ways in which the ethics rules constrain the substantive activities of judges. And I'll offer just one you and I were talking about. I had a fascinating conversation with Lucian. You're so lucky to have one of the nation's preeminent ethics experts here in the state. I did antagonize him by saying Nashville barbecue is better than Memphis barbecue, so when he rips my scholarship to shreds, it's all about the barbecue. But we talked about a recent amendment that forbids judges from expressing, and as I read it, expressing even in the form of opinions, racial prejudice, prejudice based on disrespect for groups that are sort of groups noted in equal protection lists. That's a constraint on the ability of judges to pick whatever substantive outcome they think is appropriate. I think in ways that I can't list now but might list later, there are many other ways in which the ethics rules already limit the options available to judges. And I'll just close with this thought. If you accept, as I do, the premise that environmental catastrophe now has reached the point that we're virtually in a state analogous to wartime, I think it's reasonable to expect that the obligation to address environmental harm should not be imposed solely on Congress, solely on the executive. I live in Eugene, Oregon, when some of you have followed this lawsuit where youth are suing the federal government to stop climate change. And I think some people recognize the courts may very well be one arena in which meaningful change can occur. And also, as Michael has pointed out, it's always wise for each of us to assume, all of us in the profession, to assume individual duties, even when, as is most often the case, there is no compulsion from outsiders. We read the ethics book and see how we should comport ourselves. I believe cognizance of environmental harm and a genuine attempt to reduce that harm should be part of our ethical duties. And now I welcome everyone's thoughts, and I may very well be wrong, and I'll learn, but I will respect your input. Thank you for considering my thoughts.
We're going to try to get all of you in before we have to have people leave for class. So.
Got it. I'm Lucian Pera. Thanks for inviting me. Thanks to Vanderbilt and ELI and ELPAR. I am not in the academic world, so this is an unusual format for me. I will say that I'm reminded of one of the former chairs of the Federal Reserve who said that his job essentially was to take away the punch bowl just as soon as the party got to the... So that may be my role here today. And let me get one other thing out of the way. I'd like to apologize in advance to Professor Leininger for my next 10 minutes or so of comments. I'm not sure the organizers or the professor knew who they were inviting when they invited me. Well, as those who know me will tell you, when you ask me my opinion, I'm likely to give you my opinion. So I should also tell you a little bit about my background, which is irrelevant. I've been involved in drafting and revising ethics rules for quite some time. I was on the Ethics 2000 committee, as was mentioned, that rewrote the model rules from 97 to 2002. And I've been involved in one way or another, small or large, in pretty much every ABA ethics revision since then. Here in Tennessee, I chaired the TBA committee that convinced our court to get us to the model rules after 30 years with the lovely old Code of Professional Responsibility. And I've been involved in every revision since then of that rule, those rules. I was also on the committee that drafted the Judicial Ethics rules in Tennessee, moving us to the model rules. For more than 2 decades, I've represented lawyers,
In defending disciplinary complaints, I've represented complainants making disciplinary complaints. I've represented judges responding to disciplinary complaints, and I've represented complainants against judges in disciplinary matters. And pretty much every day I deal with these rules, deal with lawyers and judges on these rules for good or ill. And from that experience, though many who know me would not agree, I've learned some measure of humility. Writing a good rule or statute is damned hard work. It's almost impossible. And so I do sympathize with Professor Leininger's efforts here. And I do have some drafting concerns about some of his proposed rules, but my concerns go far beyond that. I should say it's an interesting thought experiment. And for me, they are good. The rules, the proposals are a good reminder of the proper purpose and reach of judicial ethics rules and of what they should and should not do. Now, at the core of my comments here is the fact that not every issue about how lawyers act, and should represent clients is a legal ethics issue. And certainly, more importantly for today's purpose, not every issue about how judges act and how they judge is a judicial ethics issue. Judicial ethics rules are disciplinary rules. They're a set of enforceable minimum conduct standards. If you violate one as a judge, then you get punished or disciplined. Every jurisdiction in America takes this view. They're not aspirational, and they shouldn't be. No judge you would ever want to elect or appoint or who you'd ever want to appear before, whether as a lawyer or a client, sees these rules as describing the kind of judge they want to be. Indeed, you can be a perfectly terrible judge and comply strictly and perfectly with the judicial ethics rules. And these rules don't get, by the way, enforced quickly or easily. Usually they're enforced by a separate judicial disciplinary process, one that everywhere is slow and complicated and unwieldy, and by the way, most places secret. And anybody who assumes, and I'm not trying to get too personal with the professor here, I'm speaking generally, but anybody who assumes that because you adopt a new rule, it's going to get complied with as written, as if by magic, and anybody who believes that has not looked at how these rules work in the real world, or for that matter, looked at how any law works in the real world. To put it mildly, these rules are not self-executing. They are simply not. Now, the judicial ethics rules, just like the lawyer ethics rules, they are the wrong place to accomplish any goal other than defining, deterring, and disciplining misconduct. Okay? To be clear, I understand the professor's purpose here. I may have a word or two about that before I close. But I understand in a narrower sense the purpose here is to affect the outcome in environmental law cases by revising the judicial ethics rules to make concerns about climate change particularly a higher order value for judges, equal to or higher than some other policy concerns. And candidly, my rooting interest in that agenda, in most of the cases I'm sure he's concerned about, is on the professor's side. But as a philosophical matter, as a matter of good and proper policymaking, it is, in my opinion, wrong to use, and I rebel at using, judicial misconduct rules to accomplish other goals, perhaps goals that can't be accomplished right now by other means. Now, before I go on about this, let me just say out loud, I'm not a climate denier. I believe in, well, science, of all things. I realize it's a sad commentary that we have to say that out loud these days, but there it is. I'm all for changing public policy to deal aggressively with human-driven climate change, but not the judicial ethics rules. I'll also mention, by the way, that I represent a large number of plaintiffs' lawyers, indeed all over the country, and though they include a number of lawyers and law firms who some in this room would know, who have brought and are bringing what might be earth-changing litigation that is going to be thrown out of a bunch of courts before it might be successful elsewhere. And I work with them not on a daily basis, but I have on a regular basis to keep their lawsuits alive, to keep them on the right side of the ethics rules, actually to get them litigation funding, of all things. And I wish them the best. I've worked with them hard to make that happen. So I'm a friendly to the cause, both personally and in my paid work for clients. But I strongly resist the notion that climate change or any right-wing or left-wing or centrist policy agenda about environmental matters ought to be embedded in the judicial ethics rules, or even that environmental cases ought to be treated differently by judges in terms of judicial conduct than the values now embedded in the ethics rules would dictate. From a judicial ethics point of view, the most urgent environmental case, in my view, should be treated no differently than a securities fraud case, even an urgent one, let's say. If I were of a certain political persuasion, I'd call it social engineering by judicial ethics. I'm not, and I don't, but I'm just telling you, that's the way this can be viewed in a less analytical framework. Now, if you have any doubt that these proposals do actually try to elevate some particular public policy values at the expense of others, take a look at the proposed amendment to Rule 2.18. That's the one that imposes a duty of caution, or the precautionary principle, when addressing a catastrophic risk. Do we, in fact, have some sort of overwhelming social or public policy or political consensus that the risk of what the professor calls catastrophic risk outweighs all other concerns? I'm certainly not aware of that. I'm not aware of that kind of consensus, and the judicial ethics rules are not a place to attempt to enact such a policy into the law. If you don't think that's what's going on here, then tell me what you would think of inserting, for example, in place of the professor's phrase, large-scale harm to human health or to the environment, insert in place of that some other value and see how that would work. Maybe large-scale harm to property. Would a patent case where the decision might shut down a factory that employs 1,000 people be important enough for this kind of special treatment, or a case whose outcome might decide whether 800,000 people are deported next month? The professor would have us make a value judgment that large-scale harm to human health or to the environment is more important than any, not just large-scale, harm to, for example, property or deportation. The judicial ethics rules are simply no place to do the choosing on those issues. Another example of the proposals using the judicial ethics rules to elevate one important policy value over another is his attempt to codify and rewrite the political question doctrine into the judicial ethics rules by amendment to Rule 2.7. Now, why codify that as an ethics rules and not codify a dozen other doctrines that you guys are all learning about here, including, let's say, for example, the various flavors of judicial abstention? Or take a look at his effort to establish the legitimacy of non-human interests, including the interests of the unborn and the unconceived, okay, regardless of what other substantive or procedural law now has to say about the legitimacy of those interests being pursued, being represented, being decided on in court. That's in his proposed Rule 2.6. Suddenly, the Leininger Model Code of Judicial Conduct starts to look like Wright and Miller or Moore's Federal Practice. The strategy of tinkering with the judicial ethics rules is also, frankly, not effective. Amending these rules to accomplish goals other than defining, deterring, and disciplining misconduct, frankly, in my view, is a fool's errand. For example, experience teaches that the lawyer ethics rules are a terrible place to try to get lawyers to be more tech savvy. Good luck with that. Or trying to get lawyers to actually promote, not simply to outlaw egregious acts against, but to promote diversity. And we can talk later if we have time about the Rule 8.4G, but there's a difference between minimum standards of conduct and affirmative establishment of larger policy. Likewise, in addition to using the ethics rules for purposes for which they weren't designed or adopted, disciplining judges for acting badly in environmental cases would be ineffective to halt or slow climate change. If you think judges need to learn more science, for example, requiring judicial CLE focused on science isn't going to do the trick, ladies and gentlemen. That's in proposed Rule 2.5. And oh, by the way, wouldn't it be more important in today's world, and more positively affect more litigants' lives if family law judges got education in psychology? Well, or might that tempt a judge into playing psychologist on the bench rather than relying on the actual proof offered by the parties and proof that's tested by cross-examination? Would that be a problem for one of the professor's well-educated scientist judges? Might one of those scientist judges decide to bring on proof from their own learning and ignore the proof in front of them? Well, interestingly, the professor's proposed Rule 2.17 would grant these well-educated scientist judges a roving commission to go out themselves, figure out the science governing a case, bring it into the case, and apply it regardless of what the parties put before them. That, ladies and gentlemen, would in fact be a radical change in how our judicial systems work and our ethics rules. Now, perhaps instead, and I was about to say here, to describe the ELI's judicial education program, because how about that as an option? That sounds like a tremendous option. I was going to offer the Sedona Project as another example of that in e-discovery and complex litigation. Now, apart from abusing the purposes of judicial ethics rules and being ineffective, There's another high-level beef I have with the professor's approach. I don't believe that going to the judicial ethics rulemakers to advance the response to climate change, or even to get judges to handle environmental law cases better, is right or proper. Why not instead change the substantive law that governs these cases? Or what about changing the procedural law that governs environmental cases? Our legislatures and civil justice rules committees, for example, have been a battleground for decades, but where special interest lobbyists and others have enacted all manner of rules that govern everything from medical malpractice cases to unique ways, or workers' comp litigation, or for that matter, defamation cases. And oh, by the way, what about politics? What about judicial politics? Where are the lawyers and law professors who are drafting candidate questionnaires to put to candidates, and briefing books for governors and the Justice Department about judicial nominees' frightening lack of science literacy? What about doing studies, if you could do one? I don't know what the result would be. Studies about judges as a group who are, by and large, science idiots, or even maybe they're crypto climate deniers, I don't know. Or maybe their explicit or implicit biases cause them to rule against environmental justice and kill the planet. Okay? If any of those are true, how about a little investigation that proves that, and presenting those studies to people who decide who's going to be a judge? How about that? Maybe they'd be effective, maybe they wouldn't, I don't know, but changing the ethics rules would not. Finally, the proposal also attempts to impose discipline on judges for errors in their judging. The professor mentioned that. It's proposed rule 2.17, a fundamental premise. And I didn't understand this until probably 10 years ago, although I've been practicing far longer than that. A fundamental premise of judicial ethics is that judges generally cannot and should not be disciplined for their core work of judging. Well, that might not make sense to you, but the logic is it's supposed to be off limits to judicial discipline because that field is reserved to the court system itself. That's why God invented appellate courts, okay? Not why God invented the judicial discipline system. And that limitation on the scope of judicial discipline also preserves and protects the independence of judges, their ability to make mistakes, right, that are then supposed to be caught and corrected by the appellate system. Now, I have no interest in promoting any judicial ethics rule that in any way disciplinizes errors, factual or legal.
We're going to
My final point is very simple. No, you're quite right. My final point is very simple. I was going to reserve this for later, but one thought, which is I'm particularly troubled by the wartime point. I was around, I guess it was about a year after 9/11, and sitting next to somebody, a very conservative writer who shared the Dick Cheney view, which was that if there was a 1% chance that somebody had nuclear weapons, all bets were off, we would do whatever it took. My view is, if you care, for example, about civil liberties, you are best tested in wartime. Because the question is, would you prefer to lose your values and win the war, or would you prefer to die as a nation, as a person, and honor your values? My view on that is pretty simple, and I don't think a wartime analogy justifies any significant policy change of this nature. Thanks.
My name is Amanda Garcia. I'm the managing attorney at Southern Environmental Law Center, which is a regional nonprofit organization that uses the power of the law to advance clean energy and protect clean water in the special places that we love throughout the Southeast. We have offices and do work in 6 states, Tennessee, where I work, as well as Virginia, North and South Carolina, and Georgia and Alabama. I have been an environmental attorney for about a decade, so I'm coming at this from quite a different perspective than Mr. Pera. And at SELC and elsewhere, I've litigated cases under the Clean Water Act, the Endangered Species Act, the National Environmental Policy Act, and a number of state environmental laws. And I actually think Mr. Pera's comments are a good segue to mine in one sense, which is that I took as Professor Leininger's project, advancing the goal of his project as advancing the goal of improving public confidence in the judiciary as an independent and nonpartisan branch of government to the benefit of adequate implementation and enforcement of existing environmental laws. And I think that several of his proposals would achieve this objective or this goal, including, and the proposals that I think do the most in this regard are the ones that are clustered around transparency, promoting transparency and openness in the courts. So he proposes an actual duty of transparency, access to court proceedings and court records, which I think most people across the political spectrum would agree is a positive. Also, the proposal to clarify the duty of candor and forthrightness for judicial candidates, to allow them to opine and provide information of a general nature on substantive issues that may come before them. I believe also the continuing education suggestion is a good one. As someone who has litigated cases before judges who graduated from law school without having had the benefit of taking courses in administrative law, it would be very helpful to have continuing legal education requirements to help to bring some members of the judiciary to provide them with additional information about some of the areas of law that they may not have had as part of their own legal education. And finally, I think the duty to disqualify based on board memberships is also a positive suggestion and one that seems intuitive. Judges are supposed to not engage in conduct that could have the appearance of impropriety, and if you sit on the board of a law reform organization that has offered an opinion on an issue that comes before you, I think that clearly is something that could impugn the case and make it harder for the result to be credible in the court of public opinion. So all of those transparency-oriented recommendations that Professor Leininger offers, I think, have a lot of value for the rules of judicial ethics and to promote the public confidence in the judiciary around what can sometimes be politically contentious environmental cases. As an environmental litigator, I do want to sound a note of caution about a couple of the proposals, just based on my own experience. Professor Leininger proposes amendments to Rule 1.1 and 2.2, and these amendments would allow judges to, they're basically the obligation to comply with existing laws. The proposals would allow judges to depart from existing law if they believe in good faith that extension, modification, or reversal of existing law is necessary to achieve justice and serves the principles of the underlying existing law. And I have a few concerns here. One is I'm not convinced that these particular amendments are necessary. In my view, a good environmental litigator will creatively use existing law to achieve her client's goals. And to the extent she's arguing for an extension, she'll make it apparent that it's the logical extension of existing law applied to the facts of this particular case. And there are lots of examples of that happening right now. I think the Juliana case is a great example of that exact approach happening in the environmental arena. I have a sort of big picture concern with this proposal in that it seems to cut against the project of improving public confidence by potentially giving judges an out and the ability to ignore stare decisis in a broader set of cases and thereby chip away at the rule of law. More practically, though, I think I have a concern that these particular amendments would give the judge, or give a judge, cover to depart from well-settled environmental or procedural law in order to get rid of a case. So as a litigator, I have observed a growing trend of defense counsel aggressively pursuing legal theories that would overturn or diminish long-settled understanding of the scope of protections offered by environmental laws, including especially the Clean Air Act and the Clean Water Act. I'm also aware of extremely aggressive attempts to use standing law, Twombly-Iqbal pleading standards, and even SLAPP suits as counterclaims to defeat legitimate claims under environmental laws. And I think given the trajectory of the federal bench, we're likely to see a more receptive audience to these sorts of defense side claims than we necessarily are to creative sides on the plaintiff side. And so because the need is not particularly apparent to me and the risk is great, my reaction to that particular proposal is that it's not advisable at this time. The other one that I just will quickly flag is I actually really like the idea of a judicial ethic. I guess it would be more in the spirit of aspirational, but to give voice to intergenerational equity. But the way it comes into the proposal is through the duty of inclusion, which would expand the judge's obligation to consider all stakeholders. And I do have a kind of broader concern about that because we see so many groups that are funded by regulated parties who could take advantage of such a broadening of the rules to encompass concerns that maybe are already getting quite a lot of voice in the proceeding. But I wanted to flag that the intergenerational and non-human interests, I think Professor Leininger's article focuses primarily on climate change, but there are other and related intergenerational concerns, and I can point to several here in Tennessee, including the legacy contamination in Memphis around a lot of industrial sites that have become Superfund sites or are otherwise contaminating the city's groundwater. And those are sites that were given authorization to operate decades ago, and the city is just now understanding the risks and burdens that it took on at that time. And similarly, in East Tennessee, we have the Department of Energy's Oak Ridge facility, and there's an ongoing robust debate about whether and how radioactive waste should be stored at that facility given its groundwater site conditions and proximity to nearby surface waters. So those intergenerational concerns are real, and I think whether they're accounted for in the ethics rules or not, they are and will become an important part of these environmental cases going forward. So I'll leave it there for now. Thank you.
Thank you so much.
Well, I'm quite sure that the professor is eager to respond, but we want to cut now to Jay. And Jay, we're going to make you really big.
Muted.
Okay, we'll just leave you.
That's scary. Unmuted.
Thank you, and I do wish I could be there, and want to make sure that I am audible and everything, so if that's working, anybody in the middle of the screen could raise their hand that yes, things are fine.
Yeah, and Jay, some people had class and had to leave, but we've still got a good group here, so.
Understood. So I think it's important to explain why I guess I'm here, because I certainly don't feel that this is I am that well qualified to talk about it, and I'll defer to Lucian about the expertise on judicial ethics. I'm nowhere near a ethics nerd, but I have been the designated person to discuss legal ethics in various environmental law, like continuing legal education programs. But I did create a program to educate judges about environmental law, economics, and science almost 30 years ago, and have had that as one of the principal things that I've been doing for since 1990. So we'll just get to that particular recommendation. I certainly think that educating judges about environmental law, science, all the issues that come up is an important thing to do. I am not convinced that it's something that should be part of the code of ethics, and I guess I'm largely convinced by the points that Lucian was making on that and others. But I think that there is so much of a need for education, but it's not the substantive laws. There are so many areas. Judges are generalists for the most part in the United States. There are now 2 examples of specialized environmental courts. Vermont has had one since 1990, and Hawaii just created one a couple of years ago. So if there's a need for specialized judges or with very specialized expertise, then maybe the creation of the specialized courts is a better way to go. But I'm not convinced on that either. I value the generalist nature of judges and their ability to take a lot of things into consideration in making their judgments. To go back to the larger point, if there are going to be revisions to Judicial Code of Ethics to bring into consideration anything about the environment, I certainly think it should be very broad brush and less specific to environmental issues. I have to say I was unaware of the difference between the Code of Professional Responsibility Legal Ethics with respect to facts and judiciary. So that's a rule related to accuracy and fact-finding is one that I can see appeal to. And that should be on a general matter. It's not environment specific. It seems like it's a core function of a judge when they are called upon to make findings on fact, then it should be accurate and based on the evidence put before, and maybe there is an element of ethics in terms of ruling out certain evidence, but I think maybe that's covered by our procedural laws and may not need to be at least that explicit in the ethical. Also, the one on disqualification has some appeal for me, and I'm not sure if it maybe would broaden it, but certainly the specific things that Professor Leninger identified are concerning. So requiring disqualification for some of these where there's an obvious interest makes some sense, but I am convinced again that it's all necessary to be in the code and the ethical rules. On the precaution, that's one that for me I think does have some appeal as well. But if it's going to be considered, then I think it should be precaution written more broadly and not referring to environmental, the environment at all, but rather, if a case relates to, or is going to be dealing with something that's potentially catastrophic, then that maybe that, as a more general matter, should be something to be considered. But again, maybe these are things, by and large, that should be dealt with by the substantive law. And I will note that I've been teaching international environmental law both to judges and at George Washington Law School, and it's not. There's certainly a significant argument about whether the precautionary principle is even an element of customary international law. Maybe that's something that should be left. For many of the others, I'm not convinced that they're needed, and with some deference to a man who's actually in court, but I'm not convinced that we need transparency or inclusion or candor in the rules of ethics, and again, why they aren't taken care of by the way we run our courts as opposed to the ethics of judges. So I'll say I think that this concept makes, to me, a lot more sense as a part of the rules for lawyers than it does for judges. I think a lot can be accomplished through education of judges. I'm sorry to say that when we created the Judicial Education Program at the Environmental Law Institute in 1990, it was as a result of a judge noting that most judges had never had the opportunity to take environmental law, did not know environmental law, and that it was an obligation of the bar and ELI specifically to educate judges. Unfortunately, that really hasn't changed in 30 years, which is it's sad. We are currently embarked on a project to try and train or provide education to judges on climate science. So getting at one of the specific issues. And I close with, I certainly have heard just over the last week and weekend, assertions by Professor Michael Gerard that we are on a path towards 4-degree Celsius change in temperature, and that should put us on a wartime footing. But I still think that following the normal course of development of law and relying on judges to do their job is the appropriate course. Thank you.
Yeah, you're welcome to sit.
No, I'd love
Thank
to
you, Jay.
stand. So I want to thank the 3 commenters. Before I became an academic, I was a trial attorney, and I live for this sort of class. I'm so glad you invited me out to interact with people who have genuine concerns, expressed very cogently, about some of the recommendations I've made. So what is the amount of time that I get? I will keep it within the
I
title.
think it'd be nice just to take 5 minutes so
Okay.
that we can have a dive.
Sounds good. In 5 minutes, I will do what I used to do as a trial attorney. I would take the best concession by my opponent, and that would be the focus of my closing statement. And I admire Lucian and love his comments and consider him a friend. Comments included the following line: "You can be a terrifically terrible judge and comply with current rules of judicial ethics." If I had the mic, I'd drop it. That's what's wrong. And I believe his characterization of my proposals as intruding with unwelcome aspirational duties overlooks the fact that virtually all the present rules in the Code of Judicial Ethics, and I think Amanda alluded to this, are in effect aspirational in the sense of non-enforcement, in the sense of general hortatory nature. Consider, for example, the rule that leads off Canon 2. Judges should aspire in general to promote public confidence in the judiciary. Where's that bright line? There is none. And you can confirm this empirically by finding a large number of rules, one of which you were the proponent of, that just aren't even enforced in law. I think there's value in normative ethics. There's value in declaring important priorities. And I just want to point out the fact that this race example is very salient. And I want to commend my new friend Lucian for his leadership in including in judicial ethics and attorneys' ethics very clear guidelines that lawyers and judges may never comment in any way that's disrespectful of race. Rarely enforced, I would assume. I haven't seen any published cases in which, granted, very few ethics rules are enforced in public disciplinary proceedings. But I believe the spirit of those rules is so vital in declaring the priorities of the modern judiciary, in declaring the legitimacy, and you highlighted this point, in declaring that our courts serve societal interests and legitimizing our courts. I think that it's inaccurate to say everything I've proposed sounds more aspirational than bright line. And in fact, that very effort to carve up the authority in the world of ethics between disciplinary rules, which is where the rubber hits the road, canons of ethics, was abandoned by the ABA because it's a dichotomy that is not workable. Let me move on to some particular points. I love how he refers to me as the professor. I imagine I'm watching Gilligan's Island with the professor like making a phone out of coconuts, but I am that guy. I love it. And I get the sense that I come off today as the more radical, although maybe Amanda joins me a bit on the left. But the irony is, back in my school, I'm the most conservative guy in the halls of the University of Oregon. I advise the Federalist Society. Can you imagine? Just think of how kooky Oregon must be. I do not believe it's accurate to look at my article as the promotion of environmentally conscious rules. In fact, if you read the George Washington Law Review, the unedited version, it makes very clear these rules are not limited in focus to environmental cases, any other context in which catastrophic risk arises. For example, the large-scale dissemination of some drug that might portend ominously for human health. While there are other reasons why lawyers can disclose that, that also qualifies as catastrophic. It need not be solely environmental, although I can imagine that the short version of the article, which omits the long section describing these should apply generally in all categories of cases, might create that impression. My friend Lucian offers a thought experiment. Imagine, if you will, a provision of the ethics rules that said we could depart from normal practice if there were large-scale financial fraud. It exists. 1.6b2, 1.6b3, passed after Enron. The two elements of that disclosure ground are, first, that lawyers' services are complicit in some large-scale, and it uses terms that are virtually synonymous with the words you said. My goal is not to stake out a new realm in which we innovate new ethics duties. It's to promote harm to the environment to the same level as, say, proprietary harm, which already has permissive disclosure grounds. In 5 minutes, I might omit some of the particular responses I had in mind. Why not change the substantive? I guess with a minute left, I'm going to offer this suggestion. As an advocate to promote the environment, I've frankly tried different avenues. The Congress will say, we're not really built for this. The ideas you have don't really fit within our normal way of doing business. The executive, certainly now, will say, the way we've done business doesn't really accommodate this new radical agenda. And the courts, of course, we learned in Eugene that every once in a while a district court might take a different view, the courts are for the most part inhospitable and say our traditional procedure doesn't really abide such an argument. What avenue is left? What avenue is left? I think to impose ethics duties that in the end are mostly enforced by lawyers and judges' voluntary choice to follow precatory language in the book, rather than judges' fear that they'll be called on the carpet. I think that's an avenue that deserves experimentation. I'm sure I'm giving short shrift to Amanda's points and Lucian's points.
We'll come back.
But I wanted to stress at the end, I really appreciate comments such as my fellow speakers have made. I mean, in the long run, this exchange of ideas, I believe, is similar, and you know this from firsthand experience. When proponents of ethics rules to eliminate lawyers' ability to use inflammatory racial language first floated that idea, they ran into a wall of opposition. Brown v. Board of Education was an unusual use of the courts for goals that aren't really consistent with historic procedure. My friends bringing the Giuliani litigation are running into brick walls higher than what I face today. I do think that there is no easy way consonant with historic practice to enshrine environmental ethics. I think lawyers are a limited polity, and I do think that in a state like Oregon, where there may be 10,000 lawyers, we might very well adopt a few, not all. And so I just want to try this avenue. But let me thank once again the three speakers who shared what were in part or in whole conflicting views. I have deep respect for their positions. They've made me wiser. And I think somewhere in between our different positions lies the truth.
All right, well, we're gonna just keep going for a few minutes, and I want you to get to respond to some more. Lucian, I don't know if you want to come back and say anything before we get.
No, not really. I mean,
you were shaking your head. So.
Let me take one comment on that, which is, it is not the case that the judicial ethics rules or the lawyer ethics rules are aspirational. I mean, you can find parts of them. The canon you mentioned, if I recall, I don't have my scripture with me, but I believe the black letter that says Canon 2 or Canon 1, that is not enforceable language.
2.1 is the one I quoted.
Okay, but 2.1 is the one about what?
The general obligation not to, in 3.1 as well, they begin with the catch-all residual language that says, judge, do not, for example, 3.1 says a judge should not engage in conduct that might lead to the public view that the judiciary is in disrepute.
That's right,
and
that rule has been enforced in real cases. I mean, that's a minimum standard, a disciplinary standard, and the reason it is that way, it's like the appearance of impropriety.
There you have it.
Okay, the appearance of impropriety is still in the judicial code, and it's going to be until we're long dead, because what you're entitled to in a judge is an impartial judge and a judge who appears impartial. Okay, and that's literally in the recusal rules. So that's why 90% it seems of recusal decisions say we're not saying that Judge Smith was biased or prejudiced. Right. We're just saying it might look to a reasonable person that they were. Now that's a rule that is an enforceable rule designed to instill confidence of the public in the judge.
Two quick responses. Number one, were that criminal law being thrown out for
vagueness?
But here's the point.
That's the point.
It's not a bright line rule. And I welcome such general, which I would regard, if you don't like aspirational as a characterization of that rule, I might say hortatory. It is more general, more in the nature of standards. And I think that's the whole overall tenor of the judicial rules. I think to say that what I proposed feels more aspirational, to me, sounds like a mischaracterization of the current code as one that is entirely bright line DRs.
I mean, that's not my criticism. My criticism of it is there's a purpose. The purpose is to define, deter, and discipline bad conduct, and that I don't think you're trying to accomplish other things.
And the last thing I'll say is I really like Amanda's comment using legitimacy as the hook. And I think right now we lack good guidance about what violates 3.1, what violates those general rules. Well, perhaps more specificity, and including, none of my rules say simply environment. The idea is that they would apply, and they need not be the full extent of such rules. I don't mean to deny you or the audience a chance.
No, I mean, this is wonderful. This is exactly why we do this. We want to have this discussion. Amanda, do you have anything you want to say before we go to a question?
I'd be happy to hear from the
Oh,
audience.
okay. And Jay, do you have anything you want to say before we get a question? Okay, great. Questions? Professor Rule.
Thank you. Tom, thank you so much for coming here to visit the Vanderbilt law community. That was fabulous, and it's obviously spurred some very interesting discussion. So I'm looking for a clarification. I'm a little confused in one respect. So you're proposing revisions to judicial ethics, and as I understood, the precautionary principle rule that you would embed into those is something like, if we're in factual equipoise or there's uncertainty, kind of lean towards the environment, if that's what's at stake and there's possible catastrophic consequences. Or
So more precisely, if there is a catastrophic risk of any nature, environmental or otherwise, including sort of non-environmental harm to human health, the dangerous drug that either needs to be recalled or not recalled, and evidence and argument are at or near equipoise, and the judge faces two paths, one of which entails the catastrophic risk, and one of which does not, this rule provides a tiebreaker principle, not limited to environmental law. And I would just tell you, my brief experience as a public official, I do believe elected officials sometimes abide by such an instinct. And in many professions, and I cited a list in my article, there are many formal codifications of such a rule, but not for our judges. I think we conceive of neutrality as sort of impartiality as between parties, and that was Republican Party v. White that sort of explored why that is a little too limited. But I believe a judge also needs a basic instinct to be cautious about departing from the status quo, which may favor the plaintiff, which may favor the defendant, but taking that path less likely to trigger catastrophic harm where all other considerations are at or near equipoise.
so here's where my confusion creeps in.
Yeah.
The Juliana case has been
Yes.
used as, I take it sort of an example or a paradigm of this, but
Could you do 10 seconds on it because most people won't, a lot of people won't know.
Juliana case is the case, and there are a number of them at state court level, and it's basically, the federal government has a duty, constitutional or public trust doctrine, to take more action to prevent greenhouse gas emissions. That case is about doctrine. I mean, it's about what does the Constitution require, what does public trust doctrine require. Even if all the parties stipulate that catastrophic climate change is in our future, I'm confused as to how the judicial ethics revisions you are proposing would lead to a particular outcome in that case, given that it's all about doctrine.
So I'm not sure it applies in that case. That's a great question. I believe a better case might be a proposed development project. And there is evidence the proposed development project portends catastrophic risk of some sort. Now, were there clear on-point authority blessing the project, then that's dispositive. But where we're close to equipoise,
Well, you say
it's a tiebreaker principle.
the law is not always in equipoise. And I mean,
So
the
law and
point here,
argument together.
okay,
Law
well,
and
but I think his point may be, you're reaching over, you want to change the substantive law that governs the outcome in the case in the ethics rules. I don't think there's any question about that. I mean, because after all, we have all kinds of substantive law about who wins in a tie in a tied ballgame on a
Yes.
particular question. Indeed, we have procedural law on that. I mean, think of the standard for injunction. So I'm just trying to piece out, okay, you got substantive law, you're on an injunction hearing, and then you got the ethics rule. So how do you figure out whether you're in equipoise if you're applying one of the 4 injunctive relief factors? I mean,
So I guess,
we deal with this in other law. Why is that not good enough?
I have 2 responses. First is these hard judgment calls are endemic in ethics rules. There is just not, except for, I don't know, sleeping with clients, there just aren't really very many plain situations where a single route is obviously the right answer. So the difficulty of sorting through these circumstances matches difficulty we encounter in other areas. Is it substantive? Yes.
Well,
I wouldn't deny that it's substantive. Yeah.
Just in terms, since you raised the preliminary injunction standard, irreparable harm is a place where I could see this particular proposal coming into play, because you could have uncertainty with respect to the impacts that a particular action is going to have on an endangered species or something
So
along
change
those
that
lines.
rule.
But I think, Professor Leininger, and I'm putting words in your mouth a little bit, but I think your point is, our legal system has a pro-private property bent, and this is an attempt to bring a little bit of balance into the judge's mind as they're considering whether or not the uncertainty should fall in which direction.
And
This
I
is
might-
not an ethics question.
Well, so.
This is not even remotely an ethics question, first of all, whether we're pro-property or anti-property. Secondly, again, the ethics, judges, it is wrong, in my view, to discipline a judge for their substantive decision.
But
for
you
their
would
judgment.
if they issued an opinion declaring a race or sexual orientation
No.
to be
No,
inferior.
I disagree with
That
your.
would indeed violate the present rule against embracing out-of-bounds substantive views.
I'm
We've
not
already
convinced-
crossed that bridge.
I'm not convinced that it would. We can talk about specific cases, but I'm not convinced that, I'm not convinced that it would.
Okay. I would also say you could characterize this as a procedural rule, such like the procedural rule I faced as a prosecutor, which is when there's a tie, I lose. That's not a substantive rule. That's, in effect, really a procedural rule. But I want to be very candid. It is indeed, in my morality and ethics, it is a substantive, normative principle of ethics that when there are catastrophic consequences at stake and all other considerations don't dictate an outcome, caution dictates declination.
All right, should we go to another question? And Jay, I'm assuming you're going to wave if you want to jump in on anything. We have another, yes.
I'm Alan Fisk. I'm a private practitioner, graduated from this law school before this room was here.
Yeah.
So I've been litigating and doing transactions for about 30 years in Tennessee, mainly business transactions, business litigation, but your wartime footing language resonates with me because in my cases, we're dealing about money and sometimes lots of money. But here we're talking about lives, and it might be lots of lives, maybe the life of the planet, so it does resonate with me. But my question is, in Tennessee, a lot of our decisions about development are made at the planning commission level. My experience has been the planning commissioners are often in the pockets of big local developers. So the burden of proof, the developers seem to get the benefit of the doubt. Now, when I appeal that planning commission decision to Chancery Court, guess what? It's not de novo in most cases. Sometimes it is. Most of the times it's not de novo, and the chancellor is limited to the record. And the planning commission often blocks the record from being developed in the way the local citizens want to develop the record. You'll exclude certain evidence. We're not going to do this survey. We're not going to do this dye test to see how the water is going to be affected. And so now I'm on appeal, and I've got a limited record. Does your rules, do they help me in this kind of case where I feel like I'm hamstrung by a record developed by a planning commission that is sort of in the pocket of many developers?
Yeah, I'm not sure it does, and it is not a panacea for all circumstances. In Oregon, we make frequent use of hearings officials who are lawyers, and they are the first to review a development proposal. Those officials arguably are acting in a judicial capacity and would be subject to these rules. It is absolutely important that these rules govern the first officer or board that hears a set of facts. And as I said earlier, if law makes the facts such that they're not near equipoise, like let's take a more egregious example, I believe. The Federal Energy Regulatory Commission is really set up to deny opponents of energy projects much of a reasonable chance to protest. I don't think this rule makes much of a difference in that context. But frankly, the lack of efficacy of a rule of judicial ethics, were that sufficient to block the rules? Frankly, not many of these rules do make a difference on a day-to-day basis. I mean, we presume judges are already fairly ethical. There aren't a lot of complaints filed. I bet you get a high proportion of them. But if the argument, and I heard you make this argument, and you made it well, you made all your arguments well. But the argument that these proposals don't solve environmental harm has merit, but the judicial ethics rules individually and in total, don't really police judicial ethics very well, as you noted when you said you can be a perfectly terrible judge and still keep your seat without discipline. So it's kind of a flaw of the realm in which I'm working, but I do think that a scrupulous hearings official, such as we have reviewing development projects in Oregon, bound by these rules, might very well, in some circumstances, err on the side of caution.
One more follow. Would your rule allow the court to go outside the record and say, I'm complying with this new judicial ethic rule, so I am going to go outside the record because the science is clear X?
I think it would have to be proven. I think that judicial ethics rules don't allow judges to do independent scientific or any sort of factual investigation. That's pretty well settled. So it would
Well, how do
have
you
to be.
square that with the rule that actually says they're supposed to be aware of and go find the science and apply it?
So,
I mean, that's totally at
two
war.
different rules. One rule is the duty of continuing legal education and scientific education. The second is that judges must assess catastrophic risk. They have no means sitting passively to sort of go out and get on the internet, right? I mean, like all judicial inquiries, judges get information presented by parties. I suppose there is that one provision that already exists where a judge can interact with a third party so long as that information is made available to all litigants, but that's already in the book. Anyway, no, I don't think it changes basic courtroom procedure. It's reserved for those rare circumstances in which procedure leads to a near tie. And now if the record includes grounds on which catastrophic risk can be found, then we err on the side of caution.
I don't read the rules that he's proposed this way. I read the rules this way. You got a duty to be accurate. Seems to me you make a solid argument that if that judge, went out and found the science or applied the science from the back of her brain that she learned in one of these seminars, you could argue that that's protected. What about that duty not to investigate? Well, too bad.
That would only
This
be
is
the
conflict.
case if my language turned off the other rule that forbids
So you got to read them
independent factual
together.
investigation.
I mean, how can you
There's
be
no
accurate if you
contrary
know
language.
science to the contrary of what's in the record?
There's no contrary language.
Okay, well.
And on that note, please join me in thanking this terrific